All right. All right. Hello and welcome. Hello and welcome. Welcome to another episode of the Empowered Immigrant Live. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And thank you so much for being here. I really appreciate each of you for tuning in here today. Today, we're going to be talking about the topic of who is safe from ICE right now. All right? And so thank you for being here and welcome, and I really appreciate your joining me here this morning. So remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration law and to make the most out of their lives. All right? Today our theme is who is safe from ICE right now. And so we'll discuss that. And my question always is, hey, do you want to get a green card? Do you want to apply for asylum? Do you want to figure out what's the best strategy for you, or what option might be available for you, or how to maximize your chances of success in your immigration case for right now or for the future? Because if so, go for it. And I'd love to help you with that. All right, my firm is on a mission to win 10,000 immigration cases in the next 10 years, and we would love for your case to be one of them. All right, so thanks for being here. Thanks for tuning in. As I go through this topic today, if you have questions, feel free to submit your questions. I'll do my best to answer them. We are here right now live, and so I will do my best to answer as many questions as I can here live together here. All right, so it is March of 2025. All right. And lots of things have happened so far just in the last 6 weeks of Trump being back in power, right? The Laken-Riley Act has been signed into law, making some immigrants subject to what we call mandatory detention, all right? ICE is starting with its mass deportation efforts, and they've got a goal to arrest over 1,000 people, over 1,200 people every day, all right? They're actually working up to being able to detain 1,800 people every day. In the last 2 weeks, the Senate and the House have approved Trump's budget, which puts a lot of money into the administration's hands for the purpose of immigration enforcement. Last week, Trump announced a new gold card, which is, in my opinion, a ridiculous program, and it's ridiculous because we already have something very similar to it, right? The EB-5 program is already a opportunity for investors from outside the country to get a green card, to basically purchase a green card when they invest in the United States. And so, and the much bigger thing that happened last week was an announcement for the requirement for undocumented immigrants in the United States to quote-unquote register, all right, with the government. Another thing that happened is the Dream and Promise Act of 2025 has been introduced, and that could mean, that could be good news, and we're going to follow it to see if it actually materializes, all right? So, I want to talk a little bit more in depth. We don't have all the news about it. There's no clarity really about it. This was just announced, and it was put on USCIS's website. So I want to talk a little bit more in depth about this registry requirement because a lot of people are asking about it. And then I'll get into my topic, all right? So the registry the registry requirement, it is utilizing a law that has been dormant. It has not been utilized since the 1940s, okay? And it is, if it actually goes forward, it is requiring that people submit information to get their biometrics taken. They get their fingerprints and their photograph taken for everyone who is without lawful status in the United States. And so what I want to explain is the people who are not needing to move forward with that requirement And so basically who this applies to. All right. So basically, it applies to immigrants who are in the United States who are over the age of 14 and who have been in the U.S. without lawful status for more than 30 days. Okay? But it does not include several people who have quote unquote registered already or who have registered and done biometrics in the past. So those people include lawful permanent residents, so anyone that has a green card, anyone who was paroled into the United States, even if the parole period has expired, anyone who's been admitted to the United States on a visa, all right? You don't need, if you were given an I-94 in the past when you were admitted lawfully into the U.S., then you don't need to go through this process, all right? Everyone who's present in the United States that was issued an immigrant or a non-immigrant visa prior to their arrival, okay? Anyone who's in removal proceedings right now, because the government already has your address and they already know about your whereabouts. You're going through a legal process in front of an immigration judge, all right? Immigrants who have received employment authorization documents, immigrants who have applied for lawful permanent resident, I-485, and all the other forms related to applying for a green card. Immigrants that have been issued border crossing cards. All of these categories of folks will not need to go through this new thing of registry. Okay? And according to USCIS, right? According to USCIS, right now there is no process to do this. Like, you don't have to do this right now. Don't do it. Okay? Because they're saying that they will soon, DHS, Department of Homeland Security, will soon announce a form and a process to go through to complete this registration. And once that is up and once that is live, then I will be here and I will be sharing a lot better information and a lot better news about, hey, what does this really mean? How is it being utilized? When is it recommendable to do this and when is it not? And what are the consequences of not doing it? Right now they're saying that there could be fines and there could be, the possibility of prosecution for, it looks like a misdemeanor offense for not doing this. And so, some of these things we would just want to talk through, right? And you'll want to get good advice about. And as we know more, then we want to share this information with folks so that people can get good advice about it. And if this is useful, and if you're thinking about these issues, and if you want to stay in communication about it, I recommend that you subscribe to our channel, give us a little heart, give us a thumbs up, whatever, so that you can continue to receive videos like this and that you can continue to come to our live sessions so that you can stay informed. Okay? So that's happening. And then, and then we're going to be monitoring, as I mentioned, the Dream and Promise Act of 2025 that was introduced to the House last week as well. And so there's lots of moving parts, as always, in immigration. Okay? So I'm going to transition now to our topic just real quickly. And then if you have questions as I'm talking, please submit your questions. I'll do my best to answer them. Again, if you're tuning in right now, my name is Otis Landerholm. I am a certified specialist in immigration law, and I'm the founding attorney here at Landerholm Immigration A.P.C., where we fight for your American dream. And so thank you so much for joining me right now live, whether you're on YouTube, Facebook, LinkedIn, Instagram, TikTok. Like, hello, everyone, and thank you so much for being here. Okay? So our topic today is who is safe, quote-unquote safe, from ICE right now. I want to tell you a story. We had a client who I believed was not safe. All right? We had a client who I believed is not safe. He has a criminal record, all right? Served his time and now is facing proceedings in immigration court. He actually has a hearing in immigration court in December, okay? But he has a pretty serious criminal record, all right? And we're fighting his case. and it's not going to be an easy fight. And we know this. And, it's like, okay, this is going to be a difficult case, right? Last week, he had an ICE check-in, just a routine ICE check-in, okay? And so we were like nervous about this check-in because we know what's going on, all right? But at the same time, he's got a hearing, right? He's not he's not subject to a deportation order. He's got a case that he is fighting in immigration court, and he's got attorneys, and we're fighting for him, right? But still, I was very nervous about this particular client of mine's ICE check-in. And so what did I do? I prepared a letter for him, and I had him go in with documentation that he's complying with everything that the immigration court has requested of him, and that he's married to a U.S. citizen, and he's got children who depend on him who are U.S. citizens. And yes, he has a criminal record in the past, but we are applying, and I'm showing them the status of the various things that we are applying for him. Now, this happened a week ago, all right, a week ago today, last Tuesday. He went in, and ICE reviewed his packet, and they allowed him to leave. They did not detain him, all right? Whew, I was nervous, all right? He could have been detained, right? And so it's like, okay, that happened, and congratulations to that client. If you're listening to me right now, congratulations to you. You got through that ICE check-in, and they gave you another check-in for a year from now. So that's good, all right? You don't have to worry about detention right now. But we still got to worry about your case, right? Ultimately, it's going to come down to the decision of the immigration judge in your immigration case. And it's not going to be easy, and we got a lot of work to do to put that case together. And so that's happening, okay? And so it begs the question, right? Who is safe from ICE right now? And different ICE offices throughout the country are handling detention differently, okay? And I think it's better to be in California. I think it's better to be in the San Francisco Bay Area than in many places. So a lot of our clients are very fortunate, okay? So anyway, here is my little list of who I think is safe from ICE right now. And so let me go through them, all right? First, in my opinion, are green card holders, unless there's a reason that ICE would believe you've violated the terms of your green card. Okay, so green card holders. Second is visa holders. So if you have a current visa, and if you're still in lawful status in that visa, unless ICE believes that you have reason, or ICE has reason to believe that you violated the terms of your visa. All right. Third category is green card applicants. If you're applying for a green card, all right, I think that you're, for the most part, safe from ICE right now, unless you commit a crime, unless you have some other issue, right? If you have an approvable green card application pending, I think for the most part you're going to be safe from ICE right now, all right? If you're applying for asylum, all right, asylum applicants, for the most part, are going to be safe from ICE right now, unless your case gets denied or unless you get arrested or something of that nature, especially if you have a work permit, a valid work permit through your asylum case, all right? For the most part, folks that have valid unexpired work permits should be relatively safe, and that includes people with TPS. Yes, there are instances, but there's lawsuits that are being filed. Yes, there are instances in certain states and certain parts of the country where people with DACA and TPS have been detained. They should not be, all right? They should not be. And so for the most part, folks that have a valid work permit through TPS, through DACA, through parole in place, through parole, right, should be okay, with the one exception of the recent arrival parolees through the Biden parole programs. They're the one exception to the, parole is safe categories. Okay? You know, for the most part, for folks, what about folks that are just undocumented, right? No criminal record, but you've been in the country for more than 2 years, all right? Those folks, you could be NTA'd, right? You could be NTA'd, you could be sent to immigration court, but for the most part, for the most part, you're not like a top priority from ICE, okay? The ICE is mainly focusing on folks with removal orders, folks that are recent arrivals within the last 2 years, and folks with a criminal record. Now, there are people that are getting caught up in ICE's search. They're going to be doing raids at work and things of that nature. Like, that is true, and that will happen. But that's different from being a top priority for immigration enforcement, which you don't want to be, right? Or if you are that, you want to get a lawyer and think it through, strategize it so that you can maximize your chances of, having a game plan to fix this. Okay? So that's what I wanted to go through today. That's what I wanted to go through today. Hope that's useful. Hope that's helpful. So let me know what your questions are. And I'm seeing some questions, and as I get more questions, I'll do my best to answer them. If you're tuning in right now, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C. We're a law firm based in Oakland, California. All right, and so so thank you. So let's see. So Nepali, I see your question here. Good morning, sir. Can we apply for 2 I-130s for the same person? Or are there limits on how many times we can apply? Okay, so good question, good question. If you have multiple petitioners, imagine an immigrant has a U.S. citizen spouse and a U.S. citizen child and a U.S. citizen parent and a U.S. citizen sibling, right? All 4 of those people could petition for the person. You could have 4 petitions pending. Now, it's not really necessary, right? Because the U.S. citizen spouse or the U.S. citizen child who's over 21, those petitions are quote-unquote immediate relative petitions, both of them. And so those 2 are the ones that are going to work the fastest, right? So you don't really need multiple petitions, but you can submit multiple petitions. There's no limit. There's no problem in doing that. If one person submits the same application multiple times, then you're just going to pay a bunch of filing fees and then have them either rejected or have them, have one approved and the rest of them denied because they've already been granted, right? So you don't need to do multiple petitions when it's the same petitioner, same beneficiary. Okay, I hope that's helpful. All right, so let's see. The next is from number 1, and I see your Star of David. Thank you for that. The whole registry thing, it is awful, right? I should just say that. It's awful. My inclination is let's not do it. Let's not cooperate with it. And Trump is saying all kinds of things about everybody, everybody's going to be better off if they leave the country. Don't do that either. Bad advice. All right, you're much more likely to win your immigration case long term if you stay in the U.S. rather than leave the U.S. I just wanted to. There's rumors going out that are just false. Okay, so you got to be mindful of that. Anyway, number 1, I see your question here. U visa is approved, but only received courtesy notice without an I-94. Is it okay to apply for a green card? U visa is approved, but you only received a courtesy notice without an I-94. Is it okay to apply for a green card? Are you sure your U visa was approved? All right, are you sure? Really look at those documents. If you just receive a courtesy note, sometimes what they approve for a U visa is what they call deferred action through the U visa, which is not the actual approval of your visa yet. all right, when they approve the actual U visa, they issue an I-94. It's there in your documents. It doesn't show up as a white separate card, but it shows up on the approval notice of the I-192, the U visa waiver. Okay? And so double check how precisely what notices you got, because and if it was the actual approval of your U visa, then you got to wait 3 years and you can apply for a green card. Okay, but you really should have received an I-94. So it makes me think something maybe was done not quite right there. Okay, and it could be a government error also, or you might need to run FOIAs to see, maybe it was lost in the mail or something, but it should have been issued to you. All right, so Bickles with Angeline. I see your question here. When a case is transferred to another office, what does that mean? Yeah, right. So like imagine you file a U visa and it was filed to the Vermont Service Center, and then after a certain number of years you get a transfer notice saying that they've transferred your case to the Nebraska Service Center, for example, very common situation. What that means is, hey, now you know that if you're going to do follow-ups about your case or send inquiries about your case, now you know that you've got to follow up to that new location. But otherwise, it's the new location is just going to continue where the other office left off, and they're going to adjudicate your case, all right, and hopefully issue a decision in your case, all right. Love, care, respect. What is an EB3 unskilled-based green card application? So good question, all right. All the EB stands for employment-based. EB, EB1, EB2, EB3, EB5, right? Each of these are different categories of employment-based immigration benefits, employment-based green cards, all right? And so EB3 is the category that takes the longest. It's the slowest. It's very slow, all right? And there are certain categories of folks that can apply for an EB3 green card. You cannot apply for any employment-based green card if you are currently undocumented in the United States, which my office does not do any of the employment-based immigration green cards for that purpose. All right, my office fights for the rights of immigrants who are undocumented in the United States. And so, but other lawyers do that type of work, and you could certainly reach out to them if you have that type of case going. All right, Belinda Loyola, thank you for your question. Does having DACA mean that you are here legally? I mean, yes. DACA is not a visa. It's not a law. All right? Instead, it's a government program that granted people what we call deferred action. All right? So it's deferred action for childhood arrivals. That's what DACA stands for. And so it means that you've been granted deferred action, basically an agreement that the government will defer to act. They will not deport you for the time being while your DACA status is approved, all right? But does it mean you're here legally? Like, kind of. It's a difficult question to answer. Kind of yes and kind of no. Like, you're given a lawful work authorization document, so you 100% are allowed to work in the United States. You're given a Social Security card, right? So you're allowed to pay into Social Security and receive Social Security and all that stuff, right? But it is not really an immigration status, all right, because it has never been passed into law, and that's why it's such a complicated situation for folks. But if you have DACA, I mean, it's so much better than not having anything, all right? And so yeah, you're not accruing unlawful presence, quote unquote, because you're not unlawful in the United States. You're kind of in a middle ground, all right? So you have deferred action. That's what you have, all right? And so Let's see. Cess Lee. Can you travel with marriage-based green cards, pending, I assume, and terminated asylum? Yes, you can. All right. If you have a marriage, if your case is approved already, a marriage-based green card, and you have asylum terminated, like, yes, you can travel. Be cautious, get advice about, make sure you're really clear before traveling back to your home country, right? Because you filed an asylum application, you want them to believe you that your asylum application was honest. And when you file for asylum, you're saying your life's in danger in your home country. So that's the only thing. The only way to really be free of that is to apply for citizenship. All right, become a U.S. citizen first, and then you can travel back to your country. You know, if you once you're a citizen, then you will not be regulated that way. You know, as long as everything else was lawful, right? As long as you were honest on every other piece of the application, you'll be fine there. Anyway, but yes, you can travel otherwise. You know, a green card, when you have a marriage-based green card, it is a travel document for sure. Best advice is to just never leave the country for more than 6 months. Okay. User 7538, you say, I had my U visa approved in June of last year. Am I safe from ICE? You know, in my opinion, yes. All right, you are a valid visa holder. Congratulations. 3 years after the approval, you're eligible to adjust status and to apply for a green card. So yes, as long as you don't violate the terms of that visa, as long as you don't get arrested or have an issue with law enforcement for anything, you should be okay. All right. So let's see. Itzel Gallardo. What kind of criminal backgrounds? Really any. All right. Unfortunately, really any. And it depends on what. To answer your question fully, it would depend on what you're applying for. It would depend on what status you already have. Like, imagine you have a green card, but then you got arrested, and let's say you got arrested on an allegation of shoplifting, and later those allegations are dropped or dismissed. Well, that's not going to affect your status. All right? It's not going to affect your status. It will come up when you apply for citizenship, and it will come up when you travel, and you'll need to show that, hey, my charges were all dismissed, and here's my valid green card. Other than that, it will not affect you. Okay? However, if you are undocumented and you get charged, even falsely, for shoplifting or for anything, then you don't have valid immigration status. And so just being charged with something, like, you could be subject to immigration enforcement, not because of the crime, but just because you're undocumented, right? It can put you on the radar. And so, Itzel, the real answer to your question is, it depends on the immigration status, and it depends on the crime. Okay? Like, if somebody is convicted of possession of marijuana with the intent to distribute, right? With the intent to sell, and they have a lawful green card, and they've had it for 20 years, right? They can still be at risk of immigration enforcement, detention, mandatory detention, and then deported, because that type of crime is what we call a quote-unquote aggravated felony. All right? And so there are still things that can be applied for, right? Relief under the Convention Against Torture and other things, but those are very difficult cases. And those things, you know, anyway. So it depends on the status, and it depends on the crime. All right. And thank you. Yeah, thanks. Everybody that's tuning in right now, thank you so much for being here. I hope this is useful. I hope this is helpful. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C., where we fight for your American dream. Happy to be here with you all this morning. So, user 1036, I see your question. I have a motion to reopen denied. Can I do a joint motion with ICE or an I-246? Okay. So, you have a motion to reopen that was denied in the past. So a couple things to do. What do you do when a motion to reopen gets denied? Well, if it's denied within the last 30 days, you can appeal that denial. All right, that's possible. You can appeal the denial of a motion to reopen. So that's one way to do it. All right. If you disagree with the decision of the judge, you can appeal it. The second thing you can do is, yes, you could file again. Normally, motions to reopen have a number limit. Normally, you can only do it once. The exception to that is the one that you say, a joint motion to ICE. There's also one called a sua sponte motion to reopen, which is asking the court directly to reopen your case. Very difficult to do. Really, it's difficult to do either of those. But yes, you can try them, a joint motion, if the government is willing to join your motion. All right? Good luck with that. That's not easy. All right? It can happen, but it's very difficult, especially in the current environment. We reached out to DHS asking them to join a motion to reopen maybe 3 weeks ago under the Trump administration, and we have heard nothing back. I think that the lawyers within the Department of Homeland Security are like not sure what their guidelines are, or it's possible that they're receiving guidelines that nope, they shouldn't, or they should be very hesitant to join any motion, right? But then you also ask about ICE Form 246, all right, the I-246 form, which is a stay request made directly to ICE. Yeah, that is difficult to get approved, but that can be your last ditch effort. That can be like the final attempt to prevent or to avoid your deportation is a ICE stay. And that's done on Form I-246, like you mentioned, and that is possible, right? That is possible. It's not easy to do, but especially in this environment, but yes, it exists. Okay? Let's see, Crone Posse. I don't. Thank you for being here. You say hello, Otis. If I'm caught in a roundup, what do we do to show? What do we show as proof that we're in the green card application process? Yeah, that's a good question. If you've already filed your green card application, show receipts that your case has been filed. All right. And if you already have a work permit, show your work permit. And if you, if you don't have those things, then you could talk to your attorney. You could get a letter showing what was submitted, and even potentially with tracking information showing that your case has been submitted. There's lots of things that can be done there. Or for some folks, you have the right to remain silent. Just remain silent. Okay. All right. Efren Martinez, you're saying, are they going after green card holders with misdemeanor convictions? Good question. No, not directly, not like across the board. Not all green card holders with misdemeanor convictions. It depends on what those convictions actually were, because some misdemeanor convictions under state law cause serious problems under federal law. All right? So just because it's a felony or misdemeanor doesn't determine whether or not it's going to have immigration consequences. And so if you're worried about that, Mr. Martinez, if you're worried about that, have a consultation, talk it through, show the full records of what type of case it was, and then we can give you good advice about it. Okay? All right. Next question here is from Goldie. Goldie, I see your question. My asylum got denied from USCIS in New York City after 10 years. It was referred to immigration court. What do we expect on the first master calendar hearing? Okay, so this is for you. This is for everybody that's going to their first master calendar hearing. All right. This is what happens when I go to a master calendar hearing. All right. Let me just walk you through it. All right. Imagine there's 30 people in a courtroom. All right. Imagine that each person is given 5 minutes. in front of the judge. They go fast, all right? And in those 5 minutes, depending on your type of case, you say you have an asylum case. So in those 5 minutes, right, we would go up to the judge and we would say, hello, Your Honor, good morning. Nice to see you today. How you doing? All right, thank you. So here we are. Here's my client. This is how we're ready to proceed, right? This is how we're going to respond to the allegations and the charges in the notice to appear. Maybe we'll admit allegations 1, 2, and 3. Maybe we'll deny allegations 4, 5, and 6. We'll deny the charge of removability, right? You know, whatever, depending on what the allegations are in your notice to appear. And then we'll say, hey, and Your Honor, please don't deport my client. Why? Because he's afraid for his life to return to his home country, and we're going to be submitting an application for asylum, right? Or maybe we've got it in our hand. Here's our application for asylum, Judge. May I approach, right? Or we've already submitted the application electronically through E.C.A.S, which is the Electronic Court Application System. And Your Honor, could you please confirm that it's been received by the court? Okay, great. And so we're ready to move forward. Go ahead and set this to an individual hearing. What's your nearest date? Oh, it's in, April of 2027. Okay, great. We'll take that date. Let me confirm it's clear on my calendar. Okay, we'll take that date. Okay, counsel, thank you very much. Here's your scheduling order. Make sure all applications are up to date at least 30 days ahead of the hearing. Okay, thank you. Done. Have a nice day. All right. And then you leave the courtroom, and then you've got to comply with all the scheduling orders, and you've got to make sure that you document and calendar everything that the judge wants in advance of the final hearing, which is called the individual hearing. And that's basically what happens in a master calendar hearing. Okay? So anyway, I hope that's useful. I hope that's helpful. All right. I'm going to do two more questions, and then I'm going to wrap up. Okay, so I see a question by Free Spirit USA, and then I see a question by Kwame Darko, and then those are the last two questions I'm going to take, and then we'll wrap up. Okay, so Free Spirit USA, you say, can a recently paroled Afghan national who entered the United States via Mexico border apply for TPS? So good question. Check the rules for TPS for Afghanistan and check your date of entry. All right? Because if you recently were paroled from Afghanistan, you might not qualify for TPS. All right? It depends on how recently you applied. So it's possible, but it will depend on the date of entry and a few other factors. All right? The fact that you were paroled in from the border does not cause a problem directly for your TPS application. It's really the question of when. All right, I hope that was helpful. And my last question for today is from Kwame Darko. You say, hello, my I-130 was approved. Does that mean if I apply for an I-485 marriage-based green card that it will get approved? No, it does not. Thank you for asking that question. What the I-130 means, I'm glad that it was approved. The I-130 is the petition that belongs to your spouse or belongs to whoever the petitioner was. That petition is about your relationship. It's proving your relationship. All right? Proves that, yes, my spouse is a U.S. citizen, and yes, we are lawfully and in good faith married, for example. All right? And so that's what's been approved. Now, if you're going to apply for your green card, now you're going to need to show that you are eligible to use that petition. So that's when they ask, were you lawfully inspected and admitted or paroled in the United States? And are you admissible? Right? Have you ever been arrested? Have you ever used or possessed, cultivated, sold, had anything to do with any illegal drug, narcotic, including marijuana? Have you ever lied to immigration for any reason? Have you ever claimed to be a U.S. citizen before? Have you ever unlawfully voted in the United States? They'll go through all. Have you ever helped any other immigrant enter the U.S. without permission? They'll ask all the inadmissibility questions, to make sure that you're eligible to use the petition that was filed. All right? And as long as you are admissible, and as long as you were lawfully admitted, inspected and admitted, or paroled into the U.S., then they can approve your green card. Okay? That's the way it works. That's the way it works. All right, you guys. Thank you all so much for being here. Sorry that I didn't answer. There were a few other questions that came in there at the end on different platforms. So sorry I wasn't able to answer every single one of them. If you speak Spanish, I'll do this episode in Spanish in just a few moments. And so join us in Spanish in just a few moments if you want to. And thank you all so much for being here. I really appreciate it. Again, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C., where we fight for your American dream. If this content was useful, please take a moment, subscribe to our channel in YouTube. All right? When you subscribe, if you hit the bell, the notifications bell, that's the best way you'll receive a notification whenever we upload an additional video. All right? And that's additional updates and news and things of that nature, going on in immigration. So that's the best way to stay in communication, with our office and with our team as things are happening, as changes are being made. All right? I do have a quick special announcement for clients of our office. So, and this is just this week. I'm recording this right now on the 4th of March. In 2 days, on Thursday, on the 6th of March, we are going to have a client call. We're doing this every month right now during the first part of the Trump administration. We'll see how long we continue to do them. So join us this Thursday from 3 to 5 p.m. PST, Pacific time, all right? And we're going to discuss all the things that are happening in much more depth for our clients, all right? And so if you are a current client of our firm, stay tuned for emails and texts and other notifications about our client call that we're going to have this Thursday from 3 to 5. I'd love to have you there, okay? So that's all I got for today, folks. Thank you all so much for being here. I appreciate each and every one of you. Thanks for tuning in. And hey, let's make it a great day. Let's make it a great week, all right? And I'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot. Take care. Bye-bye.